Good day, my name is Wilma Cacayan. For today's video, I will tackle about the law of sales agency and credit transaction. So, this is the chapter 5. So, for today's video, I will tackle this topic. So, the learning objectives are describe and explain the nature of sales transaction and identify the function and operation of agencies in the industries and identify ways of handling credit transaction. So, the law on sales in the tourism, travel, and hospitality industry, agreement arising from the contract will have been made and potential breach from the agreement will be encountered. So, a contract of sales is one of the usual contract being encountered by the industry concerned. This will give you an overview. So, Article 1458 by the contract of sale of the contracting parties obligate and himself to transfer ownership and to deliver a determined thing and other to pay therefore a price certain in money. It is equivalent. So a contract of sale may be absolute or conditional. So the characteristic of contract of sale. So number one is a consensual. A contract of sale is perfected is mere consent. No form is prescribed for their perfection in the contract of sale except in the following instance. So this covered under the statute of frauds which must appear in writing otherwise than the sale considered unenforceable. Next is the sale of real property made through an agent, in which case the agent authority must be in writing, otherwise the agency and sale made through and avoid. Next is the bilateral. Bilateral because it gives rise to reciprocal obligations. Next is the principal. Principal because it can be stand by itself without need for another contract. Number 4 is the onerous because the consideration for each party is. So there are the requisites of contract sale. This is a consent, subject matter, and cause of consideration. So when we say subject a consent is manifested as a meeting of the other. The offer which must be certain and acceptance which must be absolute upon the thing the cause which are not constitute to the contract. So the following disqualified to enter into the contract is husband and wife, and the following person cannot be purchased even at public action or judicial actions. And the subject matter is that the requisite are as follows, and it must be existing or possible, it must be illicit, and it must be determined contract of sale, and the thing is price or the subject matter. The price must be understood to be in money and equivalent. And next is the cost or consideration. It represents the why of the contract or the essential reason which moves the contracting parties to enter the enter the contract. So for the seller, the consideration must be price certain in money or its equivalent. For the buyer, their consideration is a thing is contract of sale. So the effect of loss the object and contract sale is if the thing is lost before perfection of the contract. So the contract is considered inexistent, therefore the loss in be borne by the seller based on the principle of res paret and the owner of the thing who bears consequences. If the thing is lost after delivery, the buyer bears the risk of the delivery transferred ownership following the principle of the res paret. Overview of the laws governing sales agency and credit transaction. This law regulates the relationship between parties involved in buying and selling goods, so acting as agent and granting and repaying credits. So sales of law. The sales of law are the key aspect is the formation of contracts, warranties, and the transfer of ownership and remedies for breach. So when we say sales law governs the transaction of goods between seller and buyer. So sales law governs the transaction of goods between a seller and a buyer. So it typically covers a topic such as formation of contracts, and warranties, transfer of ownership, and revenues for breach any contract. So the key aspect include formation of contracts. So what is formation of contracts? So it covers the essential of elements required for the valid contract, such as mutual consent, offer and acceptance, consideration, and capacity. And then, when we say warranties, sellers may provide express or implied warranties regarding the quality, fitness for purpose, and condition of goods and being sold. So, these warranties provide legal recourse for buyers in case of defects or nonconformity. Next is the transfer of ownership. Law of determine with ownership of goods transferred from the seller to the buyer. So this includes rules regarding delivery, title transfer, and risk of loss and passing of rights and liabilities. Last is the remedies for breach of contracts. In the event of breach of the contract, sales law provide remedies such as specific performance, damages, and rescissions or restitution to ensure injured parties are fairly compensated. Number two is the agency law. So when we say agency law deals with the relationship between a principal and agent who acts on behalf of the principal. So it defines the right duties and obligation of both parties and govern issues such as authority and of the agents and the fiduciary duty owned by the agents to the principal. And the next is the liability of the principal for the acts of the agent. So these are the key aspects. So what is agent authority? So agent authority, it establishes the extent of the agent authority to act on behalf of the principal, distinguishing between actual and apparent and applied authority. And the next is the fiduciary. Fiduciary duty. Agent of fiduciary duties to act in the best interest of the principal, maintain confidentiality, exercise unreasonable care, and avoid conflicts of interest. And when we say principal liability, agency law determines the extent of a principal liability for acts or contract entered into by their authorized agent, including instant of ratification, undisclosed principles, and a vicarious liability. So, number three is the credit transaction law. So, when you say credit transaction law, the granting of the repayment or credit loans. So, between parties, it covers topics such as the term of condition of the credit agreement, interest rates, and repayment schedules, and legal remedies for default. So, these are the key aspects. So, for you is what is a credit agreement? So, credit agreement law regulate the terms of condition of credit agreement, including interest rates and repayment schedules and penalties for defaultment. Number two is the consumer protections. So, the credit transaction law often includes specific provision to protect consumer from predatory lending practices, unfair terms, or deceptive practices. And the legal remedies in these cases of default or non-payment, law provide various remedies to creditors such as repossession, foreclosure, debt collection, or enforcement through court. So, law on sales agency and credit transaction ensure fairness, transparency, and it is protection for all parties involved. So while this report provided a broad overview, it is crucial to consult a specific law and regulation in your sales agency and credit transaction law aims to create fair and balanced legal framework for commercial activities, protecting the rights and interests. Thank you and God bless.